Hare Krishna. Welcome to Tax Zero YouTube channel. This is CA Ronar Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says. And today we are going to discuss two important case laws and we will do in-depth analysis for it under the GST law. And the case laws are related to section one is related to section 74 of the CGST Act, and other is related to section 7 and schedule 2 of the CGST Act. So let's dive into it. Let me allow to share my screen. What law says? In-depth analysis of case laws under GST. So let's see first case for today's discussion. So first case is BP Oil Mills Limited and Aircom Cushions Private Limited versus Additional Commissioner Grade 2, and order date is 17th November 2025 and court involved was Allahabad High Court. Let's understand facts of the case. The petitioner BP Oil Mills Limited engaged in what? Manufacture and trading of mustard oil, purchase what? Raw material from a supplier in Rajasthan. Department initiated proceedings under Section 74, subsection 1 of the CGST Act, alleging what? Supplies were made by an unregistered or bogus dealer, proposing to demand IGST and also penalties. So show cause notices and appeal orders upheld the demand despite the petitioner producing what? Invoices, eBay bills, transport documents, KUM slips, bank payments, and ledger entries showing actual transactions. Even then, the show cause notice issued. It was noted that the supplier's GST registration had been cancelled. It was noted that the supplier GST registration had been cancelled and subsequently restored also, even then leading to confusion over its status at the time of supply. So issue under consideration was whether proceedings under section 74 subsection 1 of the CGST Act would be legitimately invoked against the petitioner where there was no material indicating fraud, suppression, or willful misstatement by the assessee. Whether the supplier's registration, though temporarily cancelled, was subsequently restored and documents evidence the real transactions with movement of goods and legitimate payments. All these factors are there, but even then, whether the penalty and the proceedings under section 74 are legitimate or not. Let's see what are the legal provisions. That is section 74 subsection 1 of the CGST Act 2017 dealing with extended time limit for demand or notice where fraud or suppression is suspected. So let's see assessees and revenues contentions. Assessee contended that the transactions were real and validly documented, and everything is also supported by submission by the assessee. Supplier was validly registered at the time of supply. What assessee's main contention is supplier was validly registered at the time of supply. Section 74 proceedings were wrongly invoked in absence of fraud or suppression. Whereas what revenue contended that purchases were from a dealer whose registration was cancelled, rendering supplies bogus. So demand and penalties under extended provisions were justified is what revenue contended. Let's see what High Court observed and held. The High Court quashed the orders and notices holding that there was no material to show fraud, suppression, or willful misstatement by the petitioner. Restoration of the supplier's registrations validated the transactions. Means here what happened is that earlier the registration cancelled, but after some time registration was restored, that particular supplier. So documentary evidence actual movement of goods also. So invocation of section 74 requires clear evidence of fraud, suppression or misstatement with tax evasion intent. Here there was no such intent. Thus proceedings under section 74 were declared unsustainable in law for a given case. So what principles laid down this case? Section 74 threshold is proceedings cannot be validly initiated without concrete evidence of fraud, suppression, or willful misstatement. Supplier registration status need to be carefully seen. The temporary cancellation later restored cannot be retrospectively used to invalidate otherwise documented purchases. So documentary proof is also important. Valid invoices, transfer documents, and bank payments are strong evidence of bona fide transactions and protects what taxpayers from extended proceedings based merely on a departmental suspicion. That is what the safeguards against the overreach. So conclusion for case 1 today is the High Court reinforced that the procedural protections in GST law, particularly under Section 74, cannot be lightly bypassed. Tax authorities must establish a foundation of material evidence of fraud or suppression before invoking extended actions. This judgment is a strong precedent for taxpayers facing extended assessment actions without clear wrongdoing. Very interesting, this case. Moving further, next case related to supply of services, section 7 and schedule 2. Case citation, Aircom Cushions Private Limited versus Assistant Commissioner Anti-Evasion CGST and CX Nagpur 1. Order dated latest order, that is 9th January 2026, and court involved is Bombay High Court Nagpur bench. Let's understand facts of the case. The petitioner Aircom Cushions Private Limited was allotted an industrial plot on a 95-year lease from the MIDC. What? The Aircom Cushion was allotted an industrial plot on a 95-year lease from MIDC. Petitioner assigned its leasehold rights along with the factory premises to a third party for consideration 1.5 crore with MIDC's consent and payment of transfer premium. So department issued and show cause notice under section 74 subsection 1 CGST Act alleging concealment and seeking to tax the transaction as supply of services under section 7 of the Act, that is classifiable as other miscellaneous services. Petitioner challenged the show cause notice via writ petition, contending what the transaction was a transfer of immovable property rights, and not a GST supply. So issue under consideration was whether the assignment of a long-term leasehold rights in a land and building for a consideration amounts to a taxable supply of service under section 7 and schedule 2 of the CGST Act, or whether it is a transfer of what immovable property excluded from GST is what issue under consideration. Let's see relevant legal provision, that is section 7 and schedule 2. Let's see what were the assessee's contention and revenue's contention. Assessee contended that transfer of leasehold rights is a transfer of immovable property benefits, not a GST-able service. Rights extinguished with assignment, transaction lacks supply characteristics, no nexus with company's business to qualify as a supply. Very important. So what revenue contended is that assignment amounts to supply of services under section 7 and schedule 2. Miscellaneous services, that is taxable at 18%, is what contended by revenue, and also contended that show cause notice is valid under section 74 alleging concealment of taxable supply against the fraud involved. So let's see what High Court observed and held. The court held that the assignment of leasehold rights doesn't constitute supply of services under GST. Why? It was not a lease or letting or sublease within Schedule 2. Rights were completely extinguished. Transaction was a transfer of a benefits arising from immovable property outside the GST net. So no nexus with a business of assessee, an essential element for supply under section 7. So relying on analogous of judgments, that is Gujarat High Court on leasehold assignments, the court quashed the show cause notice and allowed the writ petition in the favor of the assessee. So principles laid down by this case is assignment is not equal to supply. Transfer of long-term leasehold rights, extinguishing all rights is not a service under GST. Schedule 2 interpretation, these or lettings entries do not extend to assignments where rights end. And business nexus test is also important. Essential requirement under section 7, absent where the transaction has no relevance to core business activities. And GST cannot tax immovable transfers. Very important. So mere labeling by revenue cannot convert the immovable transfer into taxable service. So what we can conclude from case 2 is that the Bombay High Court clarified that the assignment of a long-term leasehold rights in immovable property is not subject to GST as it doesn't constitute a service supply. This protects the taxpayers from erroneous classification as taxable supplies. So that's it for today. Thank you. Thank you so much for patient hearing. If you want, you can take my contact numbers, and if you want to suggest, observe, any observation, any clarification, any queries, any questions, then do let me know via WhatsApp or email, or you can also comment below the video. Thank you. Thank you so much. If you are not yet subscribed Tax Guru YouTube channel, then do subscribe it for latest updates and video series like this. Thank you so much once again. Hare Krishna.